illegal, it becomes more risky to engage in that behavior, the cost of that behavior increases, and we have less of that behavior. And the real test is going to be whether we analyze firearms regulation the way we analyze any other kind of regulation, that we want to affect the costs and benefits of undesirable behavior or not. And that will be how the gun control debate plays out when it comes to the Second Amendment. Thank you.
We'll now begin questions from the panel. The first question comes from Mr. Philip Hoffert.
Professor Lund, proponents of expansive firearms rights argue that the Second Amendment serves as a check on an overreaching government, just as proponents of expansive speech rights argue that the First Amendment can serve as a check on abuses of governmental power. How persuasive is the analogy between the First and Second Amendments as checks on governmental abuse?
Okay, that's a fairly long story, and I'm going to try to give a summary of it. But I want to start by saying I used an analogy to the First Amendment in my opening comments, and I think there are many ways in which the First Amendment is analogous to the Second Amendment, and that analogies from the First Amendment often could be appropriately used by the courts. That does not mean you can simply mechanically transfer one thing from the First Amendment area over into the Second Amendment area, because there are a lot of relevant differences as well. Now, the reason for adopting the Second Amendment is the reasons that the nation adopted the Second Amendment is a somewhat complicated story, but let me briefly summarize it as follows. At the Constitutional Convention, the delegates faced a conundrum. They were worried that the new federal government needed a lot more military power than had been given to the federal government, the national government, under the Articles of Confederation. But they were also worried that if you gave this brand new government, which was very much more powerful in many other ways, such as the new power to tax and so on, and gave it all this military power, it would become dangerous to liberty. It could potentially become tyrannical. So there was this conundrum. How do you protect national security with a strong federal military power without threatening our liberties, because that same power could be used against them? They resolved that debate at the convention in favor of giving the federal government almost unfettered military power. And the anti-federalists, the people who were opposed to the adoption of the Constitution, were extremely exercised about this, extremely exercised about it. And it was a big part of the debates in the ratification process. When they came time to draft the Bill of Rights, Madison and the other delegates responsible in the first Congress for it did not want to diminish the federal government's power. And yet, there were all kinds of things they were willing to do in the Bill of Rights, but they did not want to diminish the federal government's power. And so they drafted the Second Amendment in this kind of strange way that, in fact, did not diminish the federal government's power, but kind of gave a kind of lip service to the whole idea that we shouldn't give the federal government all this military power because we have these militias, these state-based militias. Now, I can go through the rest of the textual arguments about the meaning of the prefatory clause, but the outcome of that is the following. When the Second Amendment was adopted, what people were thinking about primarily was the danger of government oppression and the usefulness of privately held arms in resisting oppression. It was a perfectly reasonable concern at the time. Nobody knew how this new federal government was going to behave. It was not limited to that. It was not limited to that. It also included, as the operative clause by its language clearly signals, a desire to make sure that the people were able to protect themselves, not just from the possibly dangerous new federal government, but from being disarmed and thereby left vulnerable to threats against which the federal government could not or would not protect them. Now, in the more than 200 years since the adoption of the Second Amendment, the perceived threat of federal oppression, federal tyranny, has diminished quite a lot. That's what was in the minds of the framers primarily, and that has diminished a lot. But the other purpose of the Second Amendment has not diminished. It has not diminished. And while it's true that today at the margins, an armed citizenry is something of a deterrent against governmental oppression because it raises the costs of oppression to the government, the potential costs, and thereby the risks, it is certainly the case that it is not realistic today to believe what plenty of people did believe in 1791, namely that if the federal government tried to conquer the armed populace of the United States, it would fail. That was a perfectly reasonable thing to believe in 1791, or oppress the people. They could fight back. That is a much less realistic thing today. But it does not mean that there's no marginal effect of the Second Amendment on government oppression, but by far the bigger realistic accomplishments that are possible under the Second Amendment today are enabling us to protect ourselves against threats that the government cannot or will not protect us against, primarily criminals. Thank you.
Professor Rosenthal, 3 minutes for rebuttal.
My own view is that the history is very complicated. Whenever I talk to law professors, I generally get a very clear, cogent statement about what the original meaning, what the framers' intentions were about the Second Amendment or anything. Whenever I talk to historians, I always get a different view. It's complicated, the data is noisy, and the historians have taught me to be cautious about the history. So rather than going into the complicated question of did Heller even get the history right, I'm going to take Heller as given, and then I'm going to agree with much of what Professor Lund just said, which is Heller tells us that whatever may have been the case in 1791, today, the Second Amendment is not very useful in resisting tyranny. When you've got a central army that's got helicopters and bombs and bazookas, this Second Amendment right really doesn't have much purchase. In fact, the 14th Amendment, ratified in 1868, and the vehicle by which the Second Amendment is applicable to state and local laws, one thing we can be pretty confident about is when they ratified the 14th Amendment, they weren't trying to secure a right to resist the federal government with force of arms. Resisting the federal government with force of arms, its poll numbers were falling in 1868. So the individual right that Heller tells us exists, Heller tells us has a discrete instrumental objective. It's designed to secure the right of lawful armed defense. Now that's precisely why, and I've got a paper I'm writing right now that focuses on this. I think the analogy between the First and Second Amendment, whatever its superficial appeal, is really quite misleading, because we have a discrete objective underlying this individual Second Amendment right, lawful armed self-defense. And once you focus on that, you realize why you need a lot of prophylactic regulation for the people who are more likely not carrying arms for purposes of lawful armed self-defense. But the First Amendment does not have this discrete instrumental objective in mind. The Supreme Court's rejected every effort to limit First Amendment protection to a single discrete instrumental objective. In fact, they tell us you don't even need any coherent message to get First Amendment protection. Abstract art is protected by the First Amendment because any form of expression is protected merely because it's expressive without any other instrumental objective in mind. That's going to give you one set of doctrine. But when you've got a text that acknowledges regulatory power and that has only a single discrete instrumental objective, lawful armed self-defense in mind, the doctrine ought to look very different. And that's why I think this effort to analogize between the First and Second Amendment is very wrong-headed, whether you'll look in terms of convicted felons or any other of the aspects of history regulation. I think the more you focus on the analogy, the weaker the analogy becomes.
Professor Lund, 2 minutes for a final response.
Let me take this opportunity to expand a little bit on the ways in which the First Amendment and the Second Amendment are and are not analogous. Textually, they're pretty analogous if you think about it. They both assert and protect a broad and fairly vaguely defined right. Both of them lack a lot of history indicating just exactly how broad the scope is, what exceptions there would be. And as a result, in both cases, I think the courts should, as they have in the First Amendment, go back to the original meaning of the constitutional provision in the following sense. The original meaning includes the text, which tells us some things, but doesn't tell us a lot of what we want to know, and the purpose. And in the First Amendment area, the court has done a pretty good job. I disagree with lots of the decisions, but on the whole, it's done a pretty good job of not letting the government get away with saying, well, we think it's a good idea and therefore it's constitutional. They've examined laws enacted by the governments in an effort to see whether they are inconsistent with the purpose of the free, well, I'm talking only about the free speech clause now, with the purpose of the free speech clause. And that's led to a lot of complicated doctrine and some decisions which are right and some which are undoubtedly wrong, either by being overprotective of the right or underprotective. You can do the same thing in the Second Amendment context. And the way to do that is to recognize that the original meaning includes not only the text, which doesn't tell us very much that's useful in terms of deciding cases, but also the purpose. And the focus on the original purpose of the Second Amendment leads you inevitably, I believe, to conduct some kind of means-end analysis in evaluating challenged regulations, just as it has in the First Amendment area. And the attitude with which judges conduct that means-end analysis is, I think, going to be what's going to turn out to be crucial on whether the Second Amendment just becomes kind of a joke in the sense that they say it's there, but it doesn't protect very much, or whether it will become more like the First Amendment, where the courts do a serious job of trying to protect an important constitutional right.
The next question comes from Krithika Rajkumar.
Professor Rosenthal, to what extent is international law relevant in deciding the scope of the Second Amendment?
I'm tempted to say none and sit down, but you probably wouldn't like that. And I am a law professor, so I'm not allowed, I'd lose my tenure if I just said none and sit down. So I'll say this, I stand with Justice Scalia on international law as a general matter. We're construing the United States Constitution, and that's all we should be worried about, period. Nevertheless, Justice Scalia tells me in Heller I need to worry about international law a little bit, because Justice Scalia tells us that we've inherited this Second Amendment right from the English Bill of Rights. That what the Second Amendment did was codify a pre-existing right, and as I've tried to explain, that pre-existing right from English law tolerated quite a bit of regulation. Now again, to go back to the analogy of the First Amendment, if Professor Lund knows what the original meaning of the First Amendment free speech clause is and what purpose they had in mind, my hat's off to him. I wrote a whole law review article on it, and I don't have the vaguest idea. And I don't think they did too. But if we're going to take originalism seriously, they permitted a ton of regulation of free speech back in 1791, kind of regulation today we never tolerate. They used what's called a bad tendency test in 1791, which permitted all kinds of prophylactic regulation. The big issue was whether truth would be a defense to defamation, and it's not clear what they had in mind. So it's not that I think international law is relevant, but it's that when it comes to means-end scrutiny, we face a real problem in this country because as a result of funding restrictions that Congress has put on since 1994, firearms violence research in this country has been greatly circumscribed. We don't have a lot of good data. When I first got involved in this issue, I was a lawyer working for Mayor Daley. And I contacted somebody who works on these issues at Johns Hopkins School of Public Health because I wanted to learn. And I was asking him a bunch of questions about the impact of firearms regulation on crime rates. And a lot of these questions he couldn't answer. He started getting really frustrated with me. And he finally said, you got to understand something. What you're trying to do is like trying to make the case that tobacco causes cancer before the Surgeon General's report. Can't be done. You need the Surgeon General's report. And as long as they're not funding firearms research, you're never going to get the Surgeon General's report when it comes to these gun laws. So it's pretty easy, if you don't permit any research, to then say, there's no proof any of these laws work. So that's why, at the policy level, I think it does become important to start looking at international law, because it turns out that in other parts of the world, gun control is awfully effective. Australia is one of the best examples where they had a lot of firearms in private hands. They then enacted quite restrictive laws, and they were enormously successful in driving down rates of firearms crime. We have some domestic examples as well, like New York City, which has about the toughest gun control law still extant in the country, and has also been terrifically successful in using that law to drive down rates of firearms crime. So I think that many people on the public health side of this debate like to look to international examples because at least you can find data there. Unfortunately, it is regrettably too difficult to identify adequate sources of data here.
Professor Lund, 3 minutes.
Well, if I'd been asked the question first, I would have just said none and sat down. But since Professor Rosenthal said something, I've got something to respond to. No, the international law has nothing to do with the Second Amendment, or it shouldn't. Maybe someday the Supreme Court will decide to incorporate international law into the U.S. Constitution, but they haven't done it yet, and until they do, it has nothing to do with it. Let me just respond to a couple of points that Professor Rosenthal made. First, the pre-existing right that Justice Scalia was referring to as having been codified in the Second Amendment was not the right in England. So Keller does not tell us we have to look at international law. What the pre-existing right he was referring to was a right that existed in the United States, in the states, primarily in the common law and in the state constitutions. So there is no indication in Heller that we can look at English history and look at the Bill of Rights of 1689 for some hints or evidence about what people might have been thinking the right to arms was in 1791 in the United States, but it did not. Nobody, certainly on the Supreme Court, nobody thinks that the Bill of Rights of 1689 in England was somehow incorporated into the Second Amendment. One comment on the bad tendency test and the early free speech decisions. I think it's true that for a very long time, the United States Supreme Court and a lot of other courts as well did not take the First Amendment as seriously as they should have. It took a very long time for them to start doing that. That doesn't necessarily mean, however, that when the court finally started taking the First Amendment seriously in the 20th century, that it was not following the original meaning of the First Amendment. That's a separate question, whether the First Amendment doctrine of the 20th century is a violation of the original meaning. Just because it was a long time coming doesn't mean that it was that it was not consistent with the original meaning. And certainly some members of the founding generation, James Madison in particular, had a much broader view of what the Free Speech Clause forbade than you would have guessed from the common law that existed at the time the First Amendment was adopted. And Madison was certainly very clear that the Bill of Rights was not simply adopting the law of England in the case of the Second Amendment or any of the other amendments.
Mr. Rosenthal, 2-minute final response.
History is so tricky. This guy Madison was the same guy who originally campaigned for ratification of the Constitution by saying we didn't need a Bill of Rights. And in his private correspondence, when he, after explaining why he flipped, he said, well, it can't do any harm. We should understand these people the way they understood themselves. Madison was a politician. There was a political movement toward a new constitutional convention. He wanted to head it off, and he thought the best way to head it off was with the new Bill of Rights. I looked pretty hard through Madison's papers to try to find some explanation of what he thought free speech rights were. And the closest I could come was he said, well, it's more than just a rule against prior restraint, but how much more, I don't know. That's all he said. And most people disagreed with him. We forget the Congress, both houses, by healthy majorities, enacted the Sedition Act. And all the judges upheld the Sedition Act. What historians know and law professors are still haven't really figured out is that you can't, people in the past don't think the way that we think today. They do things differently in the past. Courts had never upheld individual rights against legislation back in the 1790s. People were thinking of these rights in very primitive terms. And so that's why I think that history gives us such limited, if any, insight. If you wanted to kill somebody in 1791, the best way to do it was with a knife. Guns were hard to load, they were hard to aim, they misfired, they were very inaccurate. Guns posed very limited threats to public safety in 1791. So trying to figure out how guns got regulated in 1791 just gives us terrifically little insight into how they need to be regulated today.
And our third question from Elizabeth Vitale.
Professor Rosenthal, you maintain the right to carry guns in public threatens the ability of urban police officers to identify and investigate threats. Please point out consequences for law enforcement and public security following the Supreme Court decisions in Heller and McDonald.
Well, thus far, all that's really happened is outlier laws have been struck down, like the D.C. and Chicago laws. And if all that's happening is that the outlier laws get struck down, I think Professor Lund and I will agree that the consequences are not going to be significant. We may part company on whether that's a good or bad thing, but we'll probably agree that the consequences of Heller and McDonald won't be significant. If, on the other hand, we wind up with a Second Amendment sufficiently robust that everybody, or at least everybody who hasn't been convicted of a felony, has the right to carry guns in public, then the ability of the police to intervene on the streetscape, for example, New York's strategy of targeting criminogenic hotspots where gang members and drug dealers gather. There's a reason. Street gangs are the only type of criminals who commit crimes in broad daylight. You know, my guess is if we organized an expedition here and we had a narcotics detective leading it, within 20 minutes, he could take us somewhere where we could watch a drug deal in broad daylight. Isn't that amazing? What other kind of criminal commits crimes in broad daylight? There's a reason you don't do it, because ordinarily you think that if you commit a crime in broad daylight, you're going to get turned in. But a criminal street gang that terrorizes its community has impunity from that kind of intervention, because anybody who calls the police is going to have their window shot out the first time and their kid shot the next time. So how did New York address this situation? It identified the statistical hotspots of crime, the open-air drug markets, and it had the police intervene by stop and frisk tactics aimed at finding guns and drugs. They didn't wait for somebody to get shot, because by the time somebody gets shot, it's too late. You go to the scene and everybody says, I didn't see anything. But if you can intervene proactively, you can address crime. The New York sin, if it was a sin, is that they were so wildly successful that they probably, at some point in the middle of the last decade, they probably went past the point of diminishing returns. But nobody can argue with the wild success that New York experienced. But if you can't intervene in a high crime neighborhood until after somebody gets shot, you've already lost the fight. That's what the new policing that emerged in the 1990s learned, that you have to proceed prophylactically. And what I find so striking about that is it's also the lesson of firearms regulation in this country. Because all these laws that I canvassed that somehow emerged, despite or in tandem with the Second Amendment's regulatory power over the course of American history, they were all prophylactic laws. They were all laws, whether it's carrying concealed weapons or disqualifying people who were convicted of crimes or mentally ill from carrying firearms. They were all laws that emerged based on the recognition that by the time somebody gets shot, it's too late. The authorities have to be able to intervene early. So I'm not terrifically concerned. The only thing that happens is the Chicago and DC laws get struck down. I don't think it's going to be a good thing because, again, if handguns are illegal, it becomes riskier to have a handgun, and that raises the price, and that's a good thing. There's a fascinating study by Philip Cook and his colleagues out of Duke about how difficult it is for most young kids in Chicago to join gangs because it's so hard for them to raise the money to buy a gun. That was the effect. So I don't think it's a good thing that these laws got struck down, but I think the effects will be limited. But if we wind up with a regime where the police can't intervene on the streetscape until after somebody's been shot, I think that's going to be a terrifically bad thing, not for the people in this room. You'll all be fine, because as far as I can tell, all of you can afford to live in low-crime areas. But for the people that can't, afford, it's going to be a real problem. And I think that's the real tragedy here. Most people in the middle and upper class can afford to live in neighborhoods where liberal firearms rights probably have net social utility in terms of self-defense, sport, hunting, etc. But the poorest among us can't afford to live in those neighborhoods. That's where firearms violence is concentrated. Those are also the least politically powerful neighborhoods. Mayor Daley, I used to work for Mayor Daley, and he had a line he used to use in high-crime African-American neighborhoods that brought the house down. It may not mean anything to anybody in this room, but they loved it. He used to talk about the NRA and used to say they want to protect their liberty by letting the gangbangers run your neighborhood. Probably doesn't mean much to those of you in this room, but in those neighborhoods, they applauded till they wept, because that was the reality of their life.
Professor Lund, 3 minutes.
Yeah, I've been a little hesitant to get too deeply into the criminology of guns and the empirical studies and so on. Everybody's got studies on their side. My own belief, based on a fair amount of study of the studies and the research, is that gun control laws of the type that have been employed in this country have very little effect on violent crime. Very little effect. It's also true that the liberalization of concealed carry laws in over 40 states has probably had very little effect. You've probably heard the more guns, less crime thesis. There was a big study, the most sophisticated study that's ever been done in the area of gun control, that purported to show that when you liberalize concealed carry and there are more law-abiding citizens carrying guns, crime goes down. There's been a huge debate over the statistics used in this study and so on, but nobody has been able to show that increased crime. Certainly nobody has been able to show that. No serious person suggests it. Similarly,